Honorable Roy Jamie presiding.
You may be seated. In case Tammy Hamilton versus Bradley Martin and Bonnie Martin, and Bonnie Martin and Bradley Martin versus Rodney Dent, Nancy Dent, Lawrence Hovey, and Diane Hovey, plus the LAFCU. Council, identify for the record, please.
JJ Klaus, Your Honor, representing Brad and Bonnie Martin.
Good morning, Your Honor. Janie Harrop on behalf of Tammy Hamilton.
Morning, Your Honor. Robert Backus on behalf of Mr. and Mrs. Hoovey.
Danica Powell on behalf of LAFCU.
Your Honor, James Higgs on behalf of Rodney and Nancy Dent.
Good morning, Your Honor. Scott Kramer on behalf of Kelly Rietzl and Big Rapids Realty.
All right.
Your Honor, just for the record, I would indicate that Mr. and Mrs. Hoovey are also on this Zoom call.
All right.
Thank you.
We have a motion to bifurcate the trial. You may proceed, Ms. Hora.
Good morning, Your Honor. It's a very simple motion. It's just that it occurred to me and to us that there is very little factual overlap, only the subject of the case, really, and not the transactions that are common between the real estate case and the fraud case. The fraud case is more of a who said what when case. And so this is just a simple request to the court to divvy up the proofs in a way that makes sense and makes it easier for everyone.
Any response from anybody?
Your Honor, JJ Klaus, I concur with that. This is will actually simplify things for the court and for the fact finders if we were to bifurcate the cases.
Your Honor, Robert Backus, again, on behalf of the Hooveys. I'm going to object on the basis that the way the court rule reads, this is a bit of a extraordinary remedy. Court rules and the case law interpreting the court rule indicates that the discretion should to bifurcate should only be exercised on the most persuasive showing that convenience of all parties and a court requires such drastic action. I don't think that this is more convenient for my clients. This would require two separate trials. I believe that there's going to be a pretty big overlap of the witnesses. I believe certainly that to the extent that my clients are alleging that the Dents knew of an encroachment brings the encroachment to the forefront of our case as well. If we were to bifurcate, the Dents are theoretically not a party to the quiet title action, the adverse possession claim, and theoretically would have no basis for legal representation to defend against those claims that there's an actual encroachment there, which I think then can work a disservice in moving forward in regard to how to resolve the fraud claim. I believe that the witnesses in both cases are going to involve the Hamilton, Martin, Hoovey, Dent families. I believe they're both going to involve the credit union and the surveyor. So I don't know that there's a convenience to it. I think keeping the cases together really adds a relatively small amount to the real estate action by simply having to establish if and to what extent the Dent and the real estate defendants were aware of the existence of the encroachment.
Your Honor, I too object to the bifurcation of this. My clients are being sued by two parties, by both the Martins and the Hoveys, and they would need, in order to deal with the second fraud issue, they would need to be able to litigate first the issue of whether there was this encroachment actually existed and why why they don't believe this encroachment actually exists. And if they're you would be redoing this entire trial. All of their witnesses would be called to the second trial, because if we could prove this encroachment doesn't exist, they obviously would not have committed fraud here. It would just basically make us duplicate the same trial twice if this gets bifurcated.
Good morning, Your Honor. This is Scott Kramer. I represent the realtors in this case. There is essentially just a fraud case against them. I don't really have a position here. I mean, I've been brought into the case late. I would think that it doesn't make sense for me or my clients to participate in discovery or issues regarding this boundary line dispute. It doesn't really have anything to do with them or the claims against them. To kind of hop onto Mr. Higgs' comments, I think this is more of a timing issue than anything else. Mr. Higgs objected, but then pointed out, well, to his client, if in fact there isn't an encroachment, they probably have a complete defense here. I disagree that we would need to try that again. If the court handles these issues separately and rules that there is not an encroachment issue, we certainly wouldn't need to try that again. In a fraud case, it probably would provide us a basis for summary judgment. So we came in late. We haven't really engaged in any discovery on the defense of our case. And my understanding is that the parties feel that the boundary line issue is probably ripe for a decision. So I think that's what's motivating this motion. That was my long-winded commentary. Just to say, I don't really have a position. I'm all for judicial efficiency. And from my defense perspective, I do not see overlapping factual issues.
Your Honor, Danica Powell for LAFCU. I'm just going to kind of jump on to Attorney Backus's comments. LAFCU would likewise object to the bifurcation, strictly because the court rule in its own nature states that it's only to be granted for convenience and avoid prejudice. And it would not be convenient for the credit union, again, not to parrot completely what Mr. Backus said, but to have to defend itself twice in order to get the remedy that it's seeking. It just seems that it would be a confusing pipeline to go down if we're going to pretend that these are two separate cases, when in fact they're so factually and party-wise intertwined.
Any rebuttal?
No, Your Honor.
Any rebuttal, Mr. Klaus?
No, Your Honor.
Anything else from any other party? All right, what the court will do is take it under advisement, reread the court rule, and make a decision at a later date, probably within 2 weeks. And then we'll set trial dates. Don't think we've set them yet at this point. And anything else you want to discuss today?
No, Your Honor. We have a motion for summary disposition on the quiet title, mostly done and partly filed, but it is not properly noticed at this time. So we will notice that here shortly.
All right. Thank you. We're done for today.
Thank you, Your Honor.
We're in recess.
All right. All right, 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
Be seated. On the case of People versus Franklin George St. James II. Counsel identify for the record, please.
Thank you, Your Honor. Caitlin York on behalf of the people.
Morning, Your Honor. Gerald White on behalf of Mr. St. James.
And you are Mr. St. James?
Yes, sir, Your Honor.
This was just a status conference. And Mr. Ween, my information is Ms. Medley is going to be doing the pre-sentence report. Is that correct?
That's correct, Your Honor. She is aware that Mr. St. James is currently lodged at the Clare County Jail. She plans on interviewing him as soon as possible and asks that he be held until that interview can be completed at this time.
All right. And so as far as sentencing goes, we can set a date for sentencing for May 24th.
Yes, that should be fine, Your Honor.
All right, so we'll set sentencing for May 24th at 9:20 a.m. Anything further from anybody?
Your Honor, what time was that on the 24th of May?
9:20? Yeah.
Okay, very good. I would indicate for the court that issues that were brought up by Mr. St. James on our prior court hearing on the 16th have been resolved.
All right. Anything further? If not, we're in recess.
Thank you much, Your Honor.
We're in recess.
All right.